And just for your honest knowledge, the Commonwealth does have a written impact statement from the D-Bus company, as well as your honest knowledge, members of the D-Bus company are in the court today, sitting in the second row.
So what happened?
Your Honor, this case had proceeded to trial. The Commonwealth approved on July 6, 2011, approximately shortly around 11 p.m. Officers of the Littleton Police Department were dispatched to the Russell Street School for a bus fire. Upon arrival, the officers saw one of the buses at the close end of the baseball field was engulfed in flames, and thick black smoke was coming from the bus. Officers at this time saw a second bus, which was parked next to the first bus, also become engulfed in flames in a matter of minutes. Officers below the Littleton Police Department heard breaking of glass coming from the bus, as well as hearing from popping of tires and rubber melting from the bus. As they called the Littleton Fire Department, officers then saw a third bus coming to be engulfed in flames. It was at this time, Your Honor, that the Littleton Fire Department was able to come to the scene and was able to get the fire under control. As the fire was getting under control, the members of the U.S. Fire Marshal's office were also called to the scene. Littleton Police Department at this time saw a cardboard box of fireworks laying in the area, which they believed at that time could have been the cause of the fire to the buses. It also should be noted, Your Honor, that at this time the Department of Environmental Protection had to be called in due to diesel fuel being spilled into the potential water supply of the Littleton, the town of Littleton. At this time during the investigation, as the fire was gathered under control in the morning hours of July 7, 2011, detectives of the Littleton Police Department went back to the scene. At the scene, they located in between the two buses that were completely engulfed in flames, firework casings that had been wet. They then took those into evidence. Detectives then went to the middle school's video system, saw on a video a light-colored motor vehicle going into the parking lot of the Russell Street schools. They observed the vehicle enter the parking lot of that school. They observed fireworks being set off in the area located between the buses, and then saw the light-colored coupe exit the parking lot. With this information, Littleton Police put that information about the motor vehicle out to the public to try to see what was the cause, who the causes of this incident. Shortly after, the Littleton Police Department received anonymous phone calls stating that Mr. Osgood, as well as a man named Matt, later identified as Mr. Matt Colley, were the ones that were doing this in the Russell Street schools. Mr. Osgood is known to the Littleton Police Department. At that time, the Littleton Police then went to speak with Mr. Osgood. Mr. Osgood, on July 8th, after waiving his Miranda rights, stated that he and his friend Matthew Colley, as well as Mr. Ferris, were the ones who lit off the fireworks at the Russell Street School. They admitted to setting the fireworks off and getting close to the buses and lighting the fireworks off in between the buses. The Littleton Police Department then also spoke with Mr. Colley, who, after waiving his Miranda rights, stated that he had lit the big fireworks off in between the buses, and that he and Mr. Osgood had lit the fireworks. They then left, went to air, and then came back with Mr. Ferris, where they continued to light off the fireworks. The Littleton Police then spoke to Mr. Ferris. Mr. Ferris also stated that he, along with Mr. Osgood and Mr. Colley, had lit the fireworks. Mr. Ferris stated that he had lit one of them, but said that Mr. Colley and Mr. Osgood had lit the majority of them. Your Honor, those are essentially the facts of the case.
You have photographs there?
I do, Your Honor. Your Honor, do you want me to argue sentences?
I just noticed that the total out-of-pocket cost D-bus was $109,000, over $109,000.
Yes, sir. I don't know if you want me to argue sentencing.
Oh, hold on one second. Let me just take a look at these.
Sure, just to give you a sense of the damage.
So, three buses in total there.
Two buses were completely totaled. One of them was a brand new bus that the D-Bus company had just purchased. The third bus was not deemed a complete loss by the insurance company, but the other two were.
There's a lot more buses that they had parked.
They had 12. My understanding is 12 buses were lined in the road. Yes.
Okay. So, sure, I'll hear you.
Sure. The Commonwealth is seeking a guilty conviction in this case with its sentence based on the severity of the crime and based on the effect it has had on the D-Bus company. And the Commonwealth, along with the D-Bus company and the Littleton Police Department, have fashioned this recommendation without asking for jail time, so the three individuals can seek employment, maintain employment. I believe all three are employed, so they can maintain employment. So at least a portion of the restitution can be paid back to the D-Bus company. That was an important part of fashioning this recommendation, and that is another reason why the Commonwealth did not seek jail time in this recommendation. The Commonwealth believes that a guilty conviction is appropriate. You can see based on the pictures the devastating effect this has had. Two of the buses were completely and utterly destroyed. I personally went to the scene a couple days later and viewed the buses. They still smelled, you could still smell the rubber days later. The Commonwealth believes that their recommendation is appropriate. Just to give you an overall sense of the damage this has caused, not only the D-Bus company, but insurance company as well. The insurance company has paid out the D-Bus company approximately slightly over $185,000 has been covered for the D-Bus company. The D-Bus company on their own has out of pocket over $109,000. I think the figure, if you include employment cost, is around $120,000, which is the out-of-pocket expenses to the bus company alone, not including the $185,000 that's already been paid out to them by insurance. So around the total damage in this case, roughly, if you count both, is around $300,000. The D-Bus company is a family-owned company. They take pride in what they do. Their father started the company. Now all the siblings, two of the sisters, are in the courtroom today. Work at this company. They all, if you can see from the victim impact statement, were in fear of what actually happened. To make matters more complicated, the Department of Environmental Protection had to be brought in due to the diesel fuel being leaked into the Littleton water supply. There was a concern.
There's a big taxpayer cost on this.
Yeah, there was a concern, Judge, frankly, the town of Littleton's water supply due to this incident. The three individuals, although have no records, are 22 years old. The Commonwealth does believe they are of young adults who did this incident. They lit off fireworks, admittedly, in between two of the buses, which, to be frank, caused this incident. So the Commonwealth does believe that a guilty conviction is appropriate in this matter due to the severity of the crime, the lack of, they could have called the police at the time, they chose not to. So based on that, the victim impact statement, I think, would also.
The missile, hidden missile base, is that for those that fire? So they weren't, it's like a box of large.
Yes.
It wasn't like a few little firecrackers just
No.
thrown into the box. It was a big package of pretty lethal. They appear to be anyone looking at those would think that could cause some serious damage.
And that's why the Commonwealth is seeking a guilty conviction in this matter, but fashioned it in a way that the young individuals can maintain employment to seek restitution for the bus company.
Okay. So who has, let's start with Mr. Colley. See, two of the, Mr. Ferris and this happened in Littleton, Mr. Osgood and Mr. Ferris are from Air, and Mr. Colley came a long way also.
Yes, sir. I represent Mr. Colley. We have submitted a green sheet on this matter today. It's been a long time. We've been working on this case with the prosecution as to how this case is going to proceed, and we're trying to, although we're disparate, my client is willing to admit and wants to take responsibility for his actions. The only reason I'm asking for a continuation on that finding is he is 22, does have no prior record. His parents are in the courtroom here today. He does have full-time employment. He, from the beginning, has wanted to write a letter of apology. He's wanted to start this right off from the bat. And I suggest they were charged with wanton destruction, not malicious. They did leave, and even in the reports, as wrong as their actions were, Your Honor, the individuals and the three who they completely admitted to their responsibilities in it, but they also thought there was no fire when they left the incident. So regardless of their terrible actions, they did not believe and intend their actions to cause these consequences, which they did. I asked Your Honor to consider a continuation of that finding for 2 years, and we asked to put it down for a restitution hearing. That has been sort of, clearly there's a lot of money here. We're not, that's why we, the Commonwealth agreed that we're put it down for a hearing on that matter. I have diplomas. Mr. Colley is a graduate of Alliston High School. He's an employee currently direct hire in Natick. At the time of the incident, he was working at Monroe, Kyra, Toda, and Milford. They arrested him from his place of work, so he lost his job there. He was able to get a full-time job, and restitution will, he'll be working, and that'll be really important for him to be able to continue working in any conditions. They suggest community service, which I totally think is appropriate. I think that making money, though, and recouping some of the restitution would be more important at this point. So I ask Your Honor to accept and consider Mr. Colley for a continuation.
All right. And Mr. Ferris?
Thank you, Your Honor. Robin Normandin for Jason Ferris. Your Honor, I would echo some of the statements that were made. These three young men, they were foolish in their actions. They weren't intentionally malicious in their actions. They didn't intend this consequence. They should have seen through their actions, and had any of them been aware that there was a fire here, they would have made the appropriate phone calls. They thought the smoke that was there was just the normal smoke from the fireworks, and that's the reason that they didn't believe there was any reason to call the fire department. Judge, on behalf of Mr. Ferris, I do have some letters of recommendation. I have provided them to the Commonwealth. They have seen them. He is 23 years old. He was raised in the foster care system. With him today is foster parents that are in court for him today. He is, as you can see, he was raised primarily in the Littleton group home. And as Your Honor can see from the letter after letter from this group home, how well Jason is thought of, how well respected he is, and how well he has done, considering a very difficult upbringing. He is employed. He's working 2 jobs. He's working about 65 hours a week. He has always maintained employment. He graduated from Littleton High School. And as Your Honor is aware, there is no prior record. This is a very unfortunate situation. We've talked, and he feels awful about what happened to the town of Littleton and for the bus company and for what they're going through. Based upon his lack of any criminal record, these letters of recommendation, I'm asking the court to continue these matters without a finding. He is certainly willing to admit to his culpability in this matter.
Mr. Osgood.
Thank you for speaking on behalf of Mr. Osgood. He's 22. As he stands before you today, he still works. He worked before this incident and today at Burger King. Doesn't make a lot of money, and restitution is going to be the biggest issue on the case. As far as the facts, there was just that I don't need to correct the Commonwealth on a couple of things, but Mr. Osgood did not physically touch a firework or light a firework. He was in a remote vehicle. Actually, he filmed part of the initial lightings of some fireworks which weren't near the buses. As the parties talked about earlier, some fireworks were lit between the bus. This videotape shows that they left the area not knowing that it was about a 5-minute span between the actual fires that went out and the police came to put it out. There's no excuse for the behavior, but I do need to point out as far as the facts that he'd admit to that he agrees that he was there with, and he'd admit to sufficient facts as we put forward on the green sheet, but he did not physically light a firework on this day.
You can call the fire department either.
Correct.
Is this, now, the Superior Court charge of possession of an infernal machine, does this not qualify?
It does not qualify as a statute, Your Honor.
Okay.
That's why it was previously dismissed by the Commonwealth.
Probably, yeah. Because they're really very lethal looking whatever you want to call them, they're not firecrackers, that's for sure. It's something they put out on the 4th of July. They're large and it says hidden missile base. I don't know exactly what they are, but they look very lethal. It's a large box, very large tubes. There's about, I don't know, a dozen or so in that box, which are all, I don't know how large they are. I can't really tell from the pictures up there.
Right, just to, as far as the fireworks itself, these aren't fireworks you needed a license to get or anything of that nature. I understand that they're illegal in Massachusetts. However, these were sold retail in retail establishments, not.
Well, I have to say, with the restitution, if it's eventually put at about $109,000, $110,000, they're going to have. It's like being saddled with a mortgage at their age, practically. And it's going to take a long time to pay it off. I'll go along with the Commonwealth's recommendation. It's just too serious of an offense to give a quaff to. And I think the 3-year probation is going to be, I'm not even sure they can pay it off in 3 years, frankly, with this amount of money. I'd go along with the Commonwealth's recommendation. I know that these are misdemeanors. They're not felonies.
I just have a question, and I understand what you're saying. My client, I don't know if you recognize on that green sheet, they had an additional condition for Mr. Colley. Not only did they want it guilty for 3 years, they wanted a GPS monitor for 6 months. I would just...
Yeah, I'm not so sure about the GPS monitoring. I think they don't have records. I don't know if we have to put them on GPS. I wouldn't do that. I do think for 3 years probation. I think the restitution. The Fire Stars program with the VA's office still have it?
My understanding is that there isn't, that it depends on the town. I don't think it's, I think you have to, it depends on the towns. Each town, I think there's a budget. I don't think everyone has it anymore because it was a budget situation. I don't think our office specifically has it.
What else are you looking for here? It says 3 years probation, and then you have something.
Sorry, I'm terrible handwriting.
Restorative justice.
Restorative justice is a program that the Littleton Police Department.
Yeah, that's what I thought it said.
It says guilty 3 years probation, restorative justice, seek and maintain employment, 100 hours of community service, stay away from the bus company in the school, restitution to be determined, and
All right, so tell me about the restorative justice program.
my understanding from speaking with the Littleton Police Department is that it's essentially a program to bring the police department and the individuals in a room to discuss essentially what happened.
This is usually a program that's started through someone who's arrested or someone's occurring in the sort of where it says, you will, based upon their record, participate in the restorative justice program. I just did like a Saturday morning, it was a new program.
8 weeks.
Well, it could be any, it could be 12 weeks, depending on what it is. But if he did first prior to the being issued, I think if there's issues here for them to participate in, it's should be honest with justice now. If it's forward is to keep them from having a record. I mean, there are other things that they participate in, you know, or reasoning program or something like that. But I mean, this is beyond, I think, what the Department of Justice.
The probation saying it's not really appropriate.
Well, the Littleton Police Department specifically asked.
They're asking for it. Yeah. The thing I'm thinking, one of the reasons why it might be, I know it's meant for people that complain issues. It's a diversion program. The thing is, they don't have records, so they're in their early 20s, late 20s. They don't have records. It's their first experience in the criminal justice system, and it might be beneficial. If Littleton police recommends it.
They did. That was,
What was the recommendation?
it was part of the
Part of the sentence. You know, they have restorative justice programs for people who are in prison, so I don't think it's... I mean, you can withdraw the plea. I do, honestly, I do guilty. I do 5 years probation because the amount of restitution is going to be so substantial. Maintain employment, that would be the GPS. Full restitution, stay away from the victim's D-bus company, the school, maintain employment, is the victim witness fee, which is a misdemeanor, so $50, and the restorative justice program. But I don't think 3 years probation is enough. I mean, they set 3 buses on fire. And what could have happened? I mean, it could have been bad enough that this company lost what was their fleet. You know, it was a couple of firecrackers. It was a juvenile prank gone awry. But this was some pretty serious fireworks they're working with here. And this was, I can't believe there wasn't an intent to do some damage. And they didn't call the fire department when they realized that things did go awry. And they're misdemeanors, they're not being saddled with felonies. So I would do 5 years probation. The only reason the length of probation, primarily because of the restitution, but also because it's a serious offense, and they should realize that for the next 5 years they're looking at potentially 2.5 years in house of correction, which they may have to serve if they don't follow their probation. I mean, that's the best I can offer, I think. Do you want to have time to speak with your clients about it?
Yeah, I think we'll be seeking a motion to suppress state, if that's convenient with the court. May 18th works for counsel.
May 18th is a little crowded right now. Do we do another day?